Hi, and welcome back to Perspectives. Today, let's start talking about community corrections and alternative sentencing.
Community corrections refers to a wide range of sentences that depend on correctional resources available in the community. These types of sentences permit offenders to remain in the community under conditional supervision as an alternative to an active prison sentence. So you guys are actually really familiar with these. These are probation, parole, community service. Okay, let's start with probation. So the goal of probation is to retain some control over offenders while using community programs to rehabilitate, a far less expensive way than imprisoning someone. But probation is actually a sentence of imprisonment that's suspended. Instead, the sentence is going to be served under supervision in the community. So this is really a conditional freedom that's granted by a judicial officer to a convicted offender as long as the person meets certain conditions of behavior, right? And so this is a court-ordered sanction. So probationers, they have to abide by these court-mandated conditions or they're going to risk probation revocation. There's two types of conditions. General conditions, so these apply to all probationers that live in a jurisdiction. So it's going to be like obey the law, maintain employment, there might be a curfew, uh, pay court-ordered fines, those kind of things. Specific conditions refer to a specific probationer, and they might include something like pass a GED test. It could be drug testing. It could be continued community service somewhere. So all of those kind of things apply to just a specific probationer. So if you get a DUI, oftentimes not usually your first, but maybe your second or third DUI, they're going to put some kind of a device on your car that you have to blow into the breath analyzer before the car will start. Or they might do something where you have to blow, if you're not supposed to be drinking alcohol, they might put an apparatus on your phone where you have to blow at any point in time in the day when they call. These kind of things are examples of specific conditions. So the use of probation has significantly grown since the 1980s. In 2016, 3.6 million people were on probation in the U.S. That's about a 237% increase over 1980. But this increase is actually proportionate, to the overall increase in crime. Georgia, interestingly enough, is among the top states. It's actually number one in probation, in the use of probation. 1 in 18 people in the state are under some type of community supervision. Now, we do see that the use of probation is disproportionately male, disproportionately African American. Although women on probation did double between 1990 and 2016. Most of the time, probation is going to be used for nonviolent and drug crimes. Substance use disorders are high. There's a high prevalence for probationers and unmet treatment needs. And so when I say this, I'm talking about mental disorder, talking especially major mental disorder. So we're talking psychotic disorders, bipolar disorders, major depressive disorders. And they're not getting the treatment that they need. So they're not getting substance use or substance dependence treatment, and they're not getting treatment for these other conditions as well. Now, about 50% of probationers successfully complete their probation. About 29% had their probation revoked. And out of that 29%, 12% of those were ordered to serve time in prison. And then 17% were not ordered to serve time, but they probably had additional time put on their probation sentence, or they were ordered more community service, those type of things. And approximately 3% of probationers abscond, so they're living la vida loca somewhere, not in the jurisdiction. Okay, let's switch over to parole. Parole is a status, right? So it's the status of an offender who's conditionally released from prison by a paroling authority prior to the expiration of their sentence. They're going to be required to observe conditions of parole, very similar to what you saw with probation. They'll be placed under the supervision of a parole agency. So this is an administrative decision that's made by a paroling authority, and parolees must abide by conditions, so both general and specific, just like in probation, to avoid revocation. So parole is actually one of those problem areas in the CJ system. So this is really an issue. 2016, we had approximately 875,000 people in the U.S. that were on parole. Again, we see disproportionately male and African American. We're typically seeing the people who are released from prison under parole are nonviolent and drug offenders. Again, we see lots of substance use disorders and unmet treatment needs, so lots of major mental disorder and mental disorder in general. 57% of parolees were successful. They complete their parole. 30% of parolees will have their parole revoked. Now, remember back in probation, we saw about half and half of those who had probation revoked served time. Here you're going to see of the 30%, 27% were ordered to serve time. 3% had some probably additional conditions or community service or probation or something added. One of the problem areas here is that research has found that probation and parole revocations, they actually significantly contribute to prison admissions. That means that of all the people coming into prison, we're looking at about half of all new prison admissions. So half of the people coming in are coming in because of a revocation proceeding. So they were unable to meet the conditions of their parole or probation, and they were ordered to go to prison. So Georgia, our revocations account for about 55% of all new prison admissions. Now, one of the problems here is what we see is that the terms of parole have gotten so very strict. And I think you guys saw some of that when you watched the film A Hard Straight, right? That it was almost impossible sometimes for people to meet these terms, right? So you have to have a job, but you have to be home by 8 o'clock. You have to, I mean, there's all sorts of kind of these conflicting things. Now, as you can see here, 22% of parolees, they're going to return to prison for new crimes. So this is legitimate recidivism, right? So they got out on parole and they actually committed a new crime. Now, we could talk all day about kind of that pressure, that pushing and that pulling back into crime, and we saw some of that in A Hard Straight. 21% of the parolees, they're going to return to prison for just simple technical violations of their supervision. Now, because if we look at Smiley, was his name not Smiley? I think his name was Smiley in the film. He was the African-American male who actually had been sentenced to 1 year. And I cannot remember, I think he was on his 11th year of serving a 1-year sentence. So because these parole conditions, they have gotten so strenuous and it's almost impossible to meet them for some people, we find that prisoners are just declining to go up for parole. So when they're in, they're like, no, thank you. I don't want parole. I'm going to max out my time. Because if they max out their time, then they're going to get out of jail. They're free and clear. They have no conditions on them. There's no parole. There's no community supervision. They can do whatever they want to do without the threat of being returned back for a technical violation. So that's the term maxing out. In the content this week, you're going to see an article by Osserman about maxing out and kind of understand that a little bit more. So it's problematic when we release someone into the community without supervision. So as you could see, our 3 parolees in A Hard Straight, they really didn't have, I mean, they had some help, but they didn't have a lot of help. And you have people who are going to leave prison under this maxing out, and they're going to have zero help in reintegrating into society. And we find that the people who have zero help reintegrating into society, Well, they come back. They come back at a much higher rate than those who have some type of help. Now, the help that they received in a hard straight really wasn't that great. What we're seeing now is a movement by prisons that before someone gets out of prison, we're creating reintegration plans. So we're helping them think about these things and trying to set some of these things up. When you go to prison, any type of assistance that you might have received from the state or from the federal government, it goes away, right? And this includes like Medicaid, any kind of housing assistance, that type of stuff. And so what happens is if we let you out and no one has thought about these things, then you're getting out and you have no money for medication, no money for a doctor's office, no job. So reintegration really focuses on making sure that you have the proper ID, making sure that any type of assistance that you receive from the state or the federal government, that we get those things, working and ready to go into effect on the day that you walk out of prison. This really trying to help you find employment, those kind of things, any kind of ability to get a licensing through the state for being a barber or electrician. Now that's all problematic. Obama actually was trying to fix this, and I really don't know to what extent Trump has continued. I would think that it's on his radar, considering the influence that Kim Kardashian West and Kanye West have had in the White House. I know that seems silly to say, but they've had a lot of inroad to our current president in helping make some of these very decisive changes. But it used to be that we would teach you a trade in prison. And then when you came out, you would try to get a state license to practice this trade, all to find out that if you're a convicted felon, you don't qualify for licensure. So here we are spending money in a prison. You're taking your time and you're going through it. You're getting this training. You're thinking, wow, I've got this better life that's going to be ahead of me, and you're feeling prepared. And then you get out just to get slapped in the face to find out that you can't get a license because you're a convicted felon. So some of these rules are starting to change, and I have to tell you, I'm really not quite sure where Georgia is in that. I know that it was being looked at under our governor prior to Kemp. I'm not so sure that's continuing, but I'll look into that and see if I can't post an announcement for you. So let's quickly look at the revocation process. So revocation is an administrative action. It's not a judicial action. And it involves removing a person from probation or parole status in response to a violation of a lawfully required condition of parole or probation. So when we look at revocation hearings, these are hearings that are held before some type of legally constituted hearing body. It could be a parole board. It could actually be a judge. And it's to determine whether a parolee or probationer has violated the conditions and the requirements of his or her parole or probation. So as we talked about before, annually approximately 30% of parolees, 20% of probationers will have their conditional release revoked. Now, most of these revocations stem from a handful of violations, things like failure to report to a probation or parole officer. Now, that sounds like, okay, well, they should have done that, but it could be a conflict where they can't get off work or they can't get transportation. And so those are real problems that actually exist. Also, failure to participate in a stipulated treatment program. So this is not as simple as it seems as well. So this is also about money, right? So when you're on probation or parole, any program that you receive or that you're ordered to participate in, you have to pay for. So if you don't have a job or you don't have money outside of rent and food, then it's difficult for you to participate in these programs. And lastly, it's alcohol and drug abuse while under supervision. So generally, we do see that most of the people who do come back to prison definitely have unmet treatment needs, and alcohol and drug, they fall into that. Okay, so I want to start talking about some of the legal issues surrounding revocation proceedings. It's important to know that for our exam, you're not going to have to know like these years and all of these boxes actually correspond with a specific case. But you do not have to know these for the exam, but kind of get the general gist of kind of what is involved in the revocation process. So 1967, the Supreme Court held that probation revocation decisions require both a notice and a fair hearing, and that the probationer must have the opportunity to be represented by counsel. In 1972, we see that all revocation proceedings require the following: written notice of the specific alleged violation, disclosure of any evidence of the violation, an impartial hearing body, an opportunity to offer a defense, the right to cross-examine witnesses, and a written statement of the outcome. In 1973, we refined that just a bit. The Supreme Court rules that probationers are entitled to 2 hearings: a preliminary hearing to determine whether or not probable cause exists, and more comprehensive hearing prior to it. And a more comprehensive hearing prior to the final decision about revocation. Now, this is interesting because we're going to talk about a little bit more about probable cause on the next slide, and you'll kind of see why this one's a little bit tricky. Now, in 1979, the U.S. Supreme Court held that parole boards, they don't have to specify the evidence they used in deciding to deny parole. So this is not necessarily revocation, but I did put it in here. So they'll receive notice, but they won't tell you why, if you went up for parole, that you were denied. And in 1983, the Supreme Court held that probation cannot be revoked for failure to pay a fine and make restitution if it could be shown that the defendant was responsible for the failure, was not responsible for the failure. That's an error on the slide. Alternative forms of punishment have to be considered before imposing a prison sentence. Okay, so let's talk about some of the legal issues of probation and parole that concern your Fourth Amendment. Now, the first one is Fifth Amendment, but the rest all apply to the Fourth Amendment. So in 1984, Supreme Court rules that probationers' incriminating statements to their probation officers, it can be used as evidence if the probationer does not specifically claim their right against self-incrimination. So this is Fifth Amendment, right? You have to plead the Fifth. You have to state that you're not answering because you don't want to incriminate yourself. Now, in 1987, the Supreme Court ruled that probation officers, they may conduct searches of probationers' residence without a warrant or probable cause. So when you go on probation and subsequently parole, you do not have really any Fourth Amendment right when it comes to search. So a probation officer can walk right into your home, search all of your belongings. They can search you on the spot when you come in, and you have zero Fourth Amendment recourse. Now, in 1998, the Supreme Court declined, though, to extend the exclusionary rule to searches done by parole officers. But in 2001, the Supreme Court expanded the search authority normally reserved for probation and parole officers to police officers, but only under certain circumstances. So if you are on probation and you get pulled over, it used to be that the police would find out you're on probation. They would call your probation officer. Your probation officer would come out to wherever you are, whether it's a car search or a home search. Or what, and then the probation officer would then go through your belongings. But under certain circumstances, police officers now can go ahead and complete those searches. And so it's the interpretation of what those circumstances really do go, vary jurisdictionally. So we're going to leave it just at certain circumstances. So I thought we would go ahead and define community service, although just about everybody in the world knows what it is. So this is a form of punishment that's intended to benefit the community that's been harmed by the offender's crime. So the emphasis of community service is really not on punishment. It's not even really on rehabilitation. It's actually on accountability. So it's a form of community restitution. Um, Community service can be a positive sanction that it will evoke responsibility from the offender for his or her actions. Um, and community service greatly reduces the burden on the system of incarceration. But I will tell you that community service is most often a first line sanction. So this is your first offense, it's not a serious crime, and community service. But now community service is also incorporated into other sanctions, so other sentencing strategies like probation and parole. So let's talk about some alternative sentencing strategies. So these are also called intermediate sanctions. They really bridge the gap between probation and incarceration. So an alternative sentencing strategy is the use of a non-traditional sentence, really in lieu of imprisonment. So these sentences offer alternatives that will fall somewhere between like simple probation and outright incarceration. They're advantageous in a couple of ways, a few ways. They're less expensive per offender than prison. They're socially cost effective, meaning that we're using resources in the community while keeping control, maintaining control over the offender. And they really provide flexibility in terms of resources, time, and place. Okay, so let's look at some examples of alternative sentencing strategies. So the first one that I'll talk about is shaming. We saw an example of this on the slide that introduced alternative sentencing strategy. It's a woman who's standing outside Walmart. She's wearing a sign, walking up and down. She doesn't look happy. It says, "I stole from this store. Don't be like me. I'm a ding dong," that kind of stuff. We're seeing, judges use this fairly creatively. It's an interesting. It's an interesting sentence. I don't tend to have a problem with it for adults. You'll see, I failed to pay my child support. Um, I tried to buy drugs. You'll see all those kind of things. And so typically they'll be sentenced for a period of time where they have to go for however many days, however many hours, walk up and down the sidewalk with this sign attached to them or holding a sign. Um, with adults, really the embarrassment of this sanction lasts for about the period of time that they're using it. It's very uncomfortable. Nobody wants to go through it. So it's effective in that sense. But it really, once they're done, they're in their car or taking the bus home and they don't have their sign, then the stigma of it kind of wears off. Now, I don't necessarily agree with using this with juveniles, and this is a personal opinion, just so you know, but it's my thoughts that when you use something like this with juveniles, that stigma, it doesn't go away when the sign goes away or when you get home. If you have friends or classmates that see you from school, then this gets brought into the school and then everybody knows and everybody's making fun of you, and it can go on to Instagram and Facebook, and somebody might take a picture of you through Snapchat. All of these things, or TikTok video. I don't even know what TikTok is, just so y'all know, but maybe it's a TikTok video. I keep hearing that. So these things tend to take on a life of their own in the juvenile world, and it will follow them and maybe possibly haunt them for a long time. So I don't know that I really like this for the use of juveniles, but embarrassment is it's a strong tool. So next you're going to see a couple of boxes, one that says split sentencing, split sentences, mixed sentences, and community service. And this is kind of grouping this together. So split sentencing really is a combination of a brief incarceration followed by probation. So it could be like you're sentenced to 30 days in jail and then you are on probation for 2 years. And generally we use these things for, minor drug offenses. You also have mixed sentencing where you work during the week and you're on probation during the week, and then you have to go spend the weekend in jail or prison. And you have to do that for however many months or whatever period of time, to where every weekend you're spending it in prison or jail. We also do this kind of mixed with community service and treatment. You'll see this a lot in treatment courts. So by that I mean drug courts, mental health courts, veteran courts. Hopefully we'll get some time to talk about those. But this is where you participate in treatment through the week or for however many days, and then you spend some time going back and forth with community service, right? So working for some type of community agency, maybe washing police cars, cleaning graffiti, could be refurbishing some kind of public facilities. Okay, also really related to that is something that we call shock probation. So this is where the judge has every intent of really putting you on probation, but what they're going to do is they're going to sentence you to a time of imprisonment, right? And the idea is you're going to get to prison and you're going to be able to apply for parole. Now, unbeknownst to you, you already have parole, right? But you think you're going to prison and that it's unlikely that you're going to get parole or excuse me, probation. So you go to prison for however many days, you apply for this probation, and then you're released. So it's this idea of shock probation. But you're expecting to serve that full prison time. Shock incarceration. So shock incarceration is a little bit different than shock probation. You know it better as boot camp. Georgia had the first boot camp program, by the way, down in South Georgia in 1983. And this really makes use of boot camps to demonstrate the reality of prison life. Mainly it's used for first-time offenders, and it's just strict discipline and physical training, just like a regular boot camp. And typically the programs are going to last anywhere between 3 months and 6 months, so 90 to 180 days. Now, if you fail from boot camp, then you're returned to the general population. So the boot camps were really popular. They were being utilized a lot. There were lots of them kind of opening. But what we found is that they really don't have an effect on recidivism. So the outcomes for people who went to boot camp really did not differ significantly from people who were in prison. So they kind of fell by the wayside. I think there's still only one left in Georgia, and it might be that original one. Now with juveniles, we see two results. We see it having an impact on juveniles, but we also see it having kind of detrimental effects as well, kind of not what you were looking for effects with juveniles. So again, not really using these as much as we were, but with political waves, you're going to use them more and less during different times. So as we become more conservative with sentencing, these probably go by the wayside. But when we have tough on crime leadership, then you're going to see these start to roll back out. Okay, so let's talk about electronic monitoring. So this is sometimes called house arrest. Generally, individuals are ordered to be confined to their homes. Sometimes there are electronic monitoring using some kind of remote location monitoring. They're usually allowed to leave their homes during work hours. They can leave during an emergency as well. So this is often used with pregnant women, geriatric offenders, or people with special needs, terminally ill, or other special offender categories, because it's very, very, very expensive to house those individuals in prison. We see that this use of electronic monitoring is actually increasing, and it can actually be a specific probation or a parole condition as well.
All right, thanks for joining me. If you have any questions, please feel free to reach out.